Courtney Ernston with Midwest Business Law, joining you with our small business strategies. Today we're going to be talking about Minnesota mechanics liens. So first, if you are either a general contractor, a subcontractor, or a material supplier within the state of Minnesota, you have what we call mechanics liens rights. If you are a general contractor and you are licensed in the state of Minnesota, the pre-lien notice, which I will show you an example of what that pre-lien notice is, must be included in your written contract. Now, I've run into situations before where companies pay a bunch of money to attorneys to have these great contracts drafted, and then they will either email over or somehow give them just the first page of the contract that does not have the second or however many pages you have in your contract that contains that pre-lien language. So make sure, if you are a general contractor, that you are providing the entire contract to the client at the time that they are signing the contract that has the pre-lien notice in it. Now, if you are not required to be a licensed contractor within the state of Minnesota, the pre-lien language must be provided in writing within 10 days of the oral contract. Now, whether or not you're required to be licensed, as attorneys, we never recommend oral contracts. It just provides a number of opportunities for miscommunications, and it doesn't protect you as the contractor for a number of things that could go wrong, which includes damages to the property, attorney's fees, collections, all of that good stuff. Now, if you're a subcontractor or a material supplier, you are required to provide the pre-lien notice to the owner of the property, either by personal delivery or via certified mail. Now, just one quick point here. A lot of times people think certified mail means that the green card. So the Minnesota legislature has certain statutes where they provide both certified mail and the green card is called return receipt requested. So the mechanics lien statute does not require the return receipt requested. So the certified mail is just the little barcode on top that has the numbers, so you're able to prove that that piece of mail was delivered. Whoever it was received by is not a requirement of this statute. That pre-lien notice, if you are a subcontractor or a material supplier, must be provided either by personal delivery or certified mail to the owner of the property within 45 days of your first date of performing labor, providing materials, anything like that. And so again, I'll show you an example, or I'll show you what the pre-lien notice that you need to provide is. And one of the pieces of information that you are asked to provide is your estimated costs. Now, I've had a case where one of the material suppliers just put $1 as their estimated costs, and the court said, that's not reasonable, you need to put something in there. And so it's not required to be the exact dollar amount. We understand there's change orders and things like that, but make sure that when you're putting the dollar amount in there that it is a somewhat reasonable dollar amount based on either the estimate that you've provided to the contractor or you have some sort of basis in providing that dollar amount. Now, if you do not have the owner information of the property, you are allowed as a subcontractor or material supplier to request that information from the general contractor. And if the general contractor does not provide you that information within 10 days of receipt, if you guys end up not being paid, then the general contractor can be liable for your fees, for the money that you're owed, attorney's fees, and all of that stuff. All right, so enforcing the lien. So once you've provided the pre-lien notice, either as a general contractor through the contract or through that separate written document, or as a subcontractor or material supplier, if you're not paid, then of course you're going to be looking to enforce your lien. And so the statute provides in Minnesota that you must both record with the county recorder, depending on the type of property, and serve upon the owner. So service, again, here is either personal delivery or certified mail within 120 days of your last date of work. And so both of those things need to be accomplished. It has to be recorded, and the lien needs to be served on the owner. So please do not, make sure that you're not waiting until the 116th day to get this served, because sometimes with backups, depending on the county, like for example, Hennepin, Ramsey, Dakota, sometimes they take a few days to get these things recorded. And if there's any sort of issues with service, it can put you in a real jam. So please, if you're running up on the 90th day, it's always a good idea to start thinking about whether or not you'd like to file a lien on the property for not being paid. Then once you filed the actual lien, the statute says that you have 365 days from your last date of work. This is a common misconception. A lot of people think that they have 365 days from the date that they filed the lien, but it's from your last date of work. So if you waited until the very, very end to file your mechanics lien, you don't have a whole nother year to enforce your lien. So make sure that you're keeping those dates. Either if you're hiring a law firm, they should be keeping track of those dates for you. And if not, make sure that you're aware of when you need to enforce that lien. And so once you're running up on those 365 days, there must be a foreclosure lawsuit. So it actually has to be filed in district court. And because I assume the vast majority of you guys that are watching this have an entity, so you're an LLC, you're incorporated, something like that, you must be represented by an attorney. And so an attorney has to file all of this paperwork for you, and that has to be done. Both the lawsuit has to be started, the owner has to be served with notice of the lawsuit, and we have to file what's called a lis pendens, which is a document that's recorded on the property that says, hey, anybody who's interested in this property is currently subject to a lawsuit, and the ownership may change. So all that stuff has to be done before the 365 days expires. So again, similar to actually filing the mechanics lien itself, please don't wait until the very, very end, because things arise and you don't want to lose out on those lien rights. All right, so some key points to consider. One of the things that we run into often is that contractors will use services, and I'm only using these two because these are two that I run into a lot, and this has nothing to do with the quality or anything like that, but Level Set, Perfect, these are some of the companies that we run into a lot. So these are third-party lien processing systems or services. They are not attorney services, and if you read their terms of service when you enter into these agreements with these companies, what they will say is, hey, we're not responsible for anything. So if the owner is wrong, if you miss a deadline, if you miss whatever it is, if the lien amount is incorrect, anything like that, they're not responsible. So essentially what they are is they're a transcription process. So you go in, you type in all the information, they take that information that you provide, put that onto the lien statement itself, and then send that off. And so just be aware that these companies typically charge, a couple $100s to do this, and a lot of attorneys out there will provide this same service for a very similar, maybe slightly more cost, $50 or so, and the attorneys will actually provide you with assurances that the lien that you're filing is being done correctly, and that it's a legitimate lien. Another thing to know is that, especially if you're a general contractor, is that under the lien law, the owner does have the right to pay your subcontractors directly. So I've had, people call me in the past saying, oh, this owner's trying to call my subcontractor and they want to know how much they're owed, and I don't think they're entitled to that. The law does say that they are entitled to that information. So if your homeowner does say, I want to pay your subs directly, they are allowed to do that. Another thing to just keep in mind, if you artificially inflate your lien, so for example, let's say the amount that you're owed is $50,000 and you're just really irritated, and for whatever reason you decide to say that the amount that you're owed is $100,000, and so you file that mechanics lien for $100,000. If you do try to enforce that lien, or even if you don't, the owner can bring a claim against you under what's called slander of title. And so what that claim is saying is that this document that's filed against my property as the owner is slanderous, meaning it's wildly inflated. There's no basis. There's no reason that this is here other than to, cause me some sort of a harm. And under the law, if your mechanics lien is indeed slanderous, the homeowner can recover attorney's fees, interest, and things like that. So please make sure that when you're filing your mechanics lien, that the dollar amount that you're stating, you have a reasonable basis for that dollar amount. Now, I'm not saying it has to be to the penny. If there are things that go up and down, that's okay. Just make sure that you're not doing it maliciously. You're not filing a mechanics lien just for the purpose of trying to, get back at this homeowner or something like that. Another thing that we run into a lot is where people or companies will, for example, use Level Setter Perfect or another third party. They'll file the lien, and then they try and collect through conciliation court or some other means on that same dollar amount. And just know that if you try to do that, that you could potentially blow up your mechanics lien. And the mechanics lien is a very, very, very powerful tool because it actually gives you the right to take over that person's house, and it gives you your attorney's fees, interest, all of those types of things. And so just make sure that if you are filing the mechanics lien through, whether it's a third party, through an attorney, or you're doing it yourself, if you're trying to collect the money a different way, just make sure you're aware of that and you understand what potentially could happen if you do try to collect through other means. Also, one of the questions that I get asked a lot is, how much is this going to cost me to actually foreclose on this person's mechanics lien? And so the dollar amount I have here, I mean, it's a big dollar amount. 40 to 60,000 is an average contested mechanics lien foreclosure case. And what I mean by that is, in my experience, the vast majority of the time, once a contractor or a subcontractor tries to enforce the lien, the owner or the general contractor or whomever will try and say, oh, you did terrible work, and yada yada. And so it turns into this big battle, which is typically why the costs get inflated. Now, I'm not saying that this is the number in every case. I just want to make sure that I'm giving everybody a somewhat realistic standpoint of, it does cost some money out of pocket initially from the general contractor, subcontractor, or material supplier to move forward with these mechanics liens. Now again, remember, if you do have a properly perfected mechanics lien, meaning you have the pre-lien notice that you provided, that you filed the mechanics lien within the proper amount of time, and that you've commenced the foreclosure action, you are entitled to attorney's fees. And personally speaking, I've been very, very successful in recovering, if not all, the vast majority of those attorney's fees, interests, and costs, and things like that. But that is a cost that, as the contractor, that you have to front, while this is all going on. So I just wanted to provide you guys. So as a general contractor, the Minnesota statute is Minnesota Statute 514.011, Subdivision 1. So if you don't have this language in your contract, just go to Google, type in MN Stat 514.011, and you'll get a big long statute. It's a bunch of legal stuff. But if you're a general contractor, this is what you need to have in your contract. And the statute says that it must be in at least 10-point bold font. Okay, so this whole thing here has to be in your contract in 10-point bold font. If you're a subcontractor, so it's that same statute, it's just a little bit further down. Same exact requirement, which is 10-point bold font. But this is the subcontractor notice that goes to the owner. The subcontractor one, you actually have to type in some stuff. So, for example, so you have to type in your name and address, have been hired by your contractor, type in the name of the contractor to provide whatever it is, roofing or lumber or whatever. And then here's where we get to the best of our knowledge. We estimate our charges will be blank. So that's what I was talking about earlier. Make sure that you put in just a reasonable dollar amount there. You don't just put in $1 or $0. And so if you guys don't have this language, you can easily get this on Google. There's no additional attorney things that you need. You can just Google these statutes, and you can directly copy and paste and insert them either into your contract if you're a general contractor, or just copy this exact notice that you see on the page here if you're a subcontractor or material supplier, and then that can be sent off to the owner. So thank you very much for joining us for the Midwest Business Law Small Business Success Tips. My name is Courtney Ernston, and I appreciate your time.